Hello to all our viewers. I'm Stephanie Garces-Donay, joining you today with Pink Mike Leo Confessions. Thank you so much for joining us, to all our viewers that tune in every week, and also to our guests who I'm going to be introducing shortly. But I just want to kind of recap what we're going to be doing today in case you missed my live video a second ago. Today, we are going to be discussing how to properly pass assets to multiple adult children and minimize family conflicts after you're gone. And as we know, we all have family members that have conflicts with one another when someone is passed away. So we're going to be talking about that in detail, and I will be introducing our guests in just a second. As I mentioned, my name is Stephanie Garces-Donay. I'm a real estate and probate attorney. Doing also estate planning in Arlington Heights is where my law firm is located. We help parents secure their legacy and protect their children in the unexpected absence. Today I have a pleasure of introducing you to Jan Leasure. She is a wonderful and experienced individual in the mortgage industry. She's the president of Diamond Residential Mortgage in Libertyville, Illinois, so not too far from us. She is our mortgage expert today to cover this topic of how do you pass properly real estate property to your family and to your children without any issues. And so Jan's contact information is here located at the bottom. We will be flashing that through the show, but kind of to dive into our topic today. One of the things I want to talk about is homeownership. I do a lot of real estate in my law firm. Jan, I'm sure you do as well, and I'm sure you're going to drop a lot of knowledge on us today in that regards. But homeownership in general is so prevalent right now. People are really buying left and right with what's going on in the economy, with the rates being so low. It's one of the core goals of the American dream, if you will. And I'm going to go like this because that is, what we say as a society. Jan, you've helped thousands of people secure a mortgage for their home and refinance, I'm sure. As you know, right now, people are refinancing a lot. And many of these houses and homes and properties, people that buy these homes, they have children, they have a legacy to protect. And so sometimes they want to add them to the mortgage, or, should I add them to the deed while they're alive? I mean, there's so much that we can talk about, which we'll cover today. But before we dive into a discussion about this, again, you have a pretty impressive background, Jan. So please, would you mind sharing with the audience who you are, what you do, and what you're going to be explaining today?
Well, I'm pretty old, so I have a really long resume. I don't think the show is long enough for me to tell you everything, but I am a divorced mother of adult children myself, and I have 2 grandchildren. So the topic that we're discussing is something that has, traveled through my own mind on a personal level, throughout the years.
Sure.
I was a teacher. I was a teacher for 20 years. I now employ my former students as my assistants. So we try to keep it a family. I have been a nationally syndicated columnist. I've taught college for 10 years. I taught principles of real estate, and I actually was a realtor for a while.
Okay.
While I was teaching that. I am a divorce mortgage specialist. So some of that comes into play also when you're trying to set things up to try to leave things to your children and try to make things as clean as possible, which we always, we can't always do. And my first, I guess I'll have one disclaimer or 2 disclaimers. So unlike you, I am not an attorney. Mm-hmm. So I would say that what is the first thing to do? The first thing really would be to call Stephanie. So if you've got an issue, any of the things that I'm talking about today or that I'm contributing are not things that I would advise that you do yourself. Some of these things you can do yourself. You can look online, you can find legal documents, but that is not always the smartest thing to do. No problem in doing research, but I think that you have to have an attorney like Stephanie to really pull the trigger on these things to make sure that you're protected as well.
Yeah, absolutely. And thank you for the disclaimer there. I do appreciate that a lot. I get a lot of phone calls, as we'll talk about later, but you're right, Jan, a lot of people will call my office. The number is here below. You could text or call us at any point if you want to set up a consultation, but that's usually what I end up doing is set up consultations with a lot of clients, potential clients, because they have this question, I heard you can do this and I heard you can do that. And it's really not that simple sometimes, especially everyone's story is different. Some people are divorced. Some people have lost a loved loved one. Some people have become kind of the beneficiary of an inherited estate. And so there's so many complications to this. But excellent. Thank you, Jan, for kind of diving into your background. It's actually quite impressive. I had no idea that you were a teacher. So thank you for sharing that for all the teachers watching. I know right now is a hard time for them. So I do appreciate you at least explaining that you are in different industries in your life, that you learned a lot from, I'm sure. So I'm so thrilled to have you here with us today. And I want to discuss a couple of things, just kind of an area of expertise, just to tell our viewers what we're going to be covering today, in case I can keep their attention or not. But one of the things that we're going to be covering today is why investing in real estate is still one of the best ways to grow wealth, especially for your children and for your family, and how we pass this legacy on to our children and to our loved ones. And so that's one of the things we're going to cover. The second thing we're going to cover is what special provisions should homeowners be wary of in Illinois? What are the things that we should be reaching out for? I mean, every state is a little bit different in the laws, as you guys know, and I always tell the viewers, make sure you're checking in with an attorney that's licensed in that particular state. But in Illinois specifically, where we're located, what are the rules there as far as this passing of the property goes? And is it harder or easier if someone's from out of state passing property outside of the state? The third thing we're going to cover is the legal part, the legal documents that you need, truly need, and are required for your family to get this property that you want to leave them. Many times people will say it's better to not put anything at all in writing because I know who I want to go to. Well, I will tell you again in various times today that that's not a plan, that's a lack of a plan. And you do not want a lack of a plan, because then your family ends up being the ones to have to go through this and sort of puts them in a jam, if you will, because they don't know what to do when nothing is left written. So I'll kind of say sometimes at the end for some audience members that may have some questions for us, Jan. So if they pop in, I'll go ahead and guide you in those as soon as they message me during these topics. So that's the great part. Now, before we get into the meat and potatoes of the conversation today, I want to kind of recap for those of you that are just joining us. Like I mentioned, my name is Attorney Stephanie Garces-Donay. I'm the owner and principal attorney of Garces Law Firm in Arlington Heights, Illinois, where we help parents secure their legacy and protect their children in an unexpected absence. So in this week's Pink Mike Legal Confessions, we're going to be talking about how do we pass assets, in particular real estate property, to our loved ones. And today, my guest is Jan Leasure, president of Diamond Residential Mortgage in Libertyville, Illinois. She's going to talk to us about her expertise in this area and what you can do to ensure that you and your family are protected. Now, if you missed last week's episode, that's okay, but it is actually very important for you to watch it in case you do have children. You may want to watch this one. It's called How to Select a Legal Guardian for Your Minor Children. You can watch that right here on our Facebook page. I also have a YouTube under Garces Law if you want to check those out at any point. We welcome you to join us here every Tuesday from 2:30 to 3:30. And I wanted to make sure that the guardians and parents are watching those videos, because we do share a lot of tips, educating everyone about what is a proper way to pick a guardian for your minor children. So make sure that you guys watch that and make sure you're up to date and learn something from our videos. And I'm always open to feedback, which you can provide after the show. Okay, so Jan, we have a couple of questions that have come in through message here. People are asking a couple of things about what we're going to dive in about. So they're saying, how do we avoid our children from fighting over property after I pass away? So you can start.
My answer is pray.
I know, right? It's like
I want to micromanage from the grave. So I'm not exactly sure how you can do that, but obviously the very first option is to have everything in writing, just as you said, have some sort of a will, have it written down. And also, you've got to have stuff notarized. I don't see how you can do this without an attorney. I know that a lot of people, as I said before, go online and they say, okay, here's something I can pull up and I can just jot it down. But I don't think that'll really work. But have everything in writing, of course.
Yeah, thank you, Jan. And kind of diving into that, I always preach about this to my my audience members in general, but do not trust the internet, please. I mean, the internet's great for searching for attorneys. If you want to look me up, you want to check my Google reviews, you want to check, the attorney down the streets reviews. Absolutely, use it for that. But as far as getting legal advice from a computer, I mean, this is the type of stuff that we compete with as attorneys, because people do go online to get the generic, will offline that they think is going to work for them. But, like you said, Jan, getting in writing is step one. Number two is also go to an attorney that helps you with this. Now, one of the many things aside from a will that can really help you navigate how do you properly pass something to your children, aside from a will, we always talk about trust in this program. Now, there's a lot of different trusts, but we're going to talk about the trust that we're talking about specifically is like a living trust, for example, or maybe you have reasons to have an irrevocable trust. There's different trusts that we're going to talk about, but in general, a trust is another mechanism, we're going to say, aside from a will, that would actually pass the property to your family members when you've passed away. It's one of the many ways to do this. So just keep this in mind. And again, avoid the internet when it comes to this stuff, guys. I can't preach that enough. It's for your own protection. I always tell people, if you think about it, your house and actually for many people, Jane, maybe you can agree with this, your house is one of the biggest assets in your lifetime that you purchase. Because think about it, the average person is not buying 10 properties in their lifetime or 5. They're just buying 1 or 2 houses maybe. And so I always talk about this because people that think, okay, it's important for me to protect the most big asset. The same thing goes with the will and all of that. The house is one of the assets, maybe the biggest one, but try to get it in writing and try to go to an attorney. We always recommend that.
An interesting thing about a living trust that you may not have covered is that if you have a living trust, as opposed to a revocable trust or a land trust, you can have your property in a living trust and you can refinance your property. So you can keep it in trust when you are doing a refinance. So if somebody has a 5% rate and last year they put their property into a living trust to protect themselves and their family, and now rates are 2.8, and they want to refinance and they're like, oh crap, I just did all this work and I paid all this money. They actually can refinance and keep the house in trust without disturbing any of the wishes or plans that they made when they put the trust together.
Yeah, absolutely. And thank you for mentioning that. That's right within your realm of expertise. We have had people say, well, I've been thinking about refinancing, like which one do I do first? Well, the answer is, you really should get your estate planning order in first, because there's no point of worrying about the rates, immediately without considering an estate plan. Because like I said, things happen so quickly and we don't know from one day to another what's going to happen to us. So, it's always advisable to do that. So yes, thank you for mentioning that, Jan. I have another question that came in and see if we can tackle this one. It says, I have adult children. Does it make sense to refinance or put them on the mortgage now?
I would advise against putting anyone on the mortgage except yourself, except the people that are living in the property.
Right.
Once you have everything in place, I mean, putting your children on a mortgage is making them responsible for the debt, as well as the ownership. So what I would probably do is refinance the property if you're looking for a better rate, or whatever your strategy is, and then I would contact my attorney. I'd call Stephanie and I would say, okay, I want to put my children on the property, and you can add people to the property after you've refinanced down the road a couple of months, when everything is stable and moving along in the right direction as far as your payments are concerned. You can add people. However, and Stephanie, you would be the one to speak to this. So if you're single like I am, I could add someone else to the title of my home, so that if something happened to me, they could live in the home. They would still have to pay the mortgage. The mortgage doesn't go away when you die. We come after you.
Yeah, I know.
We'll come after someone, and you'll make you pay. But you can put other people on it, and you would be holding it as joint tenants, which is whoever is surviving still has the ownership of the property. That would be one thing to do. However, if you are married, unlike myself, and you're currently holding your owner-occupied property as tenants by the entirety, I won't get into this; it's too much information. But then you cannot add other people, to my knowledge, Stephanie, to the property.
Yeah, and kind of going off of that, someone had asked us this question the other day in regards to kind of like estate planning, because I get a lot of questions like, can I just quit claim it and add so and so? You can definitely add people, but it's not, as attorneys, we're never going to say yes, that's the best solution for an estate plan, because the reality is that, again, things happen. Do you really want to add someone to the property when in essence that's just the property? If you have different assets, checking accounts, savings accounts, maybe more than one property, maybe more than one child, there's so many scenarios, and so it's hard to kind of, let's say, have a one size fits all, is what I say with that sort of thing, because again, everyone's journey in their life and where they're at when they want to do this is completely different. And there's ways to other than adding someone to the property, which can be done, but again, not the best estate planning tool when it comes down to like you passing away. If you're joint tenants, yes, it transfers over and no issues. But what happens when that person passes away too? That's the bigger question. And that's actually where I get a lot of phone calls, Jan, where people will say, oh, well, I was a joint tenant with my mom and I have, 5 kids. And I'm divorced and this and that. And so now you're talking about this person's specific estate plan, what should we have in place? So there's so many things that we can talk about in that regards, but yeah, there are different ways. Now, and I want to bring something up that Jan talked about. Jan, you mentioned something earlier about putting someone on the mortgage. Now, my thought process is the same as yours. Why give someone more debt? I mean, if you're talking about, like, for example, a young adult, maybe a college student that is your child, and you want to put them on the mortgage with you because it'll help you get a lower rate or whatever. You're like, maybe if something happens to me, but that person grows, right? And eventually they might want to own their own place that they live in. And so, Jan, can you dive into that a little bit? I know that goes to like debt to income, right? Because if you have this house that you own but you don't live in, doesn't that sort of hurt your chances down the road to get another property?
Well, yes and no. So if you have, I've got someone right now who's actually the mom on the house, and she is a business owner. So she runs her business at a little bit of a loss, and she needs to have a non-occupant co-borrower in order to make her refinance work. So her son is going to help her out. However, he is very cognizant of the fact that being on his mother's mortgage, it's, so I'm not going to say it's great if something happens to her. Well, yes, he inherits the house. It's only at a 50% loan to value. So she has lots of equity in the property. She's very responsible. It probably wouldn't hurt his credit. However, for the first 12 months that mortgage is in effect, yes, depending on his debt to income, he may not be able to qualify to purchase his own home or to purchase a second home, or to buy a condo in the city or something like that, because his mother's mortgage, principal, interest, taxes, insurance will be held against him for 12 months. Now, after 12 months, if you can prove to your loan officer that the primary person on the property has been making the payments and they're all on time, then they can waive that debt. But for 12 months, it's right there. Or if they don't pay, that's going to affect your credit.
Yeah, absolutely. And I'm glad you brought up the 12-month thing, Jan, because I think a lot of people underestimate the time frame. So, I mean, and this is where your expertise comes in. So you're saying that if someone says, I'm going to help for example, I get a lot of this, I'm going to help my brother buy a place because I'm going to be the person on the mortgage with him and whatnot. Mm-hmm. If in 12 months after that, everything's going well, he's up to date, I can then ask my loan officer to help me in the process, maybe even, take them off the mortgage after the 12 months. Is that what you're saying?
Yes. Yeah.
Okay.
Well, or we don't count it against you if we can prove that the other person has made the timely payments for 12 months.
Got it. Okay. Okay, great. Yeah, that's good to know, because, that's where your expertise comes in, because I am not a mortgage officer. I'm not going to pretend that I know everything, but yeah, I know I have had a lot of people communicate that to me after the fact and say, well, I'm on this mortgage. My lender said it was a good idea because it'll help my mom get the house, but what happens down the road? So I never fully know how to explain this, because I don't know if this person qualifies for something else, down the road or not with the house. So that's always good to talk about.
There's always risk. Like if your parent or your child is in a difficult situation, somebody gets a divorce, they lose their job, they can't pay for their house, and that you don't have the liquid capital to help them. sure, you can refinance and you can, you can get on there with them to help them save their house, but there is a level of risk involved every time you do that. It's the same as, well, it's almost worse to put yourself on somebody's car. But I have a lot of parents that co-sign vehicles for their kids, and then they come in and they want to buy a house, and their debt to income is great, but Billy didn't pay his car, so they've got a repo on their credit or something. And they, and they can be professionals that they had 800 credit, and they thought they were teaching their child, fiscal responsibility.
Yeah, right.
And it came around to bite them. Yeah.
Right. No, that's great. I mean, that's interesting, Jan. So do you run into that a lot where people will, like, for example, like with the car payment where it kind of takes them out of the running? I mean, at what point do you tell them something like this? Because I'm sure they're shocked. They're probably like, wait a minute, what do you mean that we don't have, our credit's been injured and whatnot? Because
I had some people last year that had that their son just didn't pay on their car and the car was repossessed, and it was a joint situation, and I don't think that the parents were notified.
Oh wow,
but
okay.
They were notified by me when I ran their credit,
Of course,
it was a difficult situation. We put them together with somebody that could help them, work it out, but it's a situation that takes months. So they weren't able to act on their desires at that moment. They had to go back and undo everything that was done by their co-signing.
Yeah, I can imagine. So that would make sense. Okay, well, good. I'm glad we kind of talked about that too. I just got another message as we're sitting here. Someone is asking, how old does my child have to be to take over real estate?
We usually require that people are 21 years old. So plus if they're when you say take over, I'm not exactly sure what the person means when they say take over my real estate. They can be on title when they're 18. Mm-hmm. I'm pretty sure, but mm-hmm. If they're going to be on a mortgage, they have to have a job. So if we're talking just about when you say take over, does that mean how old do they have to be in title, or are they literally taking over the property? They're moving into the property and they're going to be handling it as the owner.
Right.
So they only have to. Yeah.
I was going to say I was going to say, what do we take it? Because it's kind of a loaded question because it's like taking over. It could mean like on the deed, which basically in layman's terms means who own, when you pull the property on the county website, who is the owner? That's the person on the deed. So I just want to point that out because I don't want to assume everyone knows what a deed is, but the deed is and I think that, like I was saying, I think it's a loaded question. So if we say the deed 18, give or take, right? But that's mm-hmm. for an adult. But as far as a mortgage, you're saying 21 is more of like is that the recommended age? Because by the time that they're 21, they actually have a full-time job, or you're saying 21 is what you've seen?
21 is what I've seen. Yeah. We have not done a lot of mortgages for kids that are just out of high school. And that's primarily because they don't usually, now they can do it, and they don't need a 2-year job history. 2-year job history is standard in whatever your profession is, whether you're a W-2 employee or self-employed. We like to see 2 years of history. If you're a recent high school graduate, but let's say you go work for your mom and dad, and they give you a job making $45,000 a year, at 18 you could qualify for a mortgage. So age isn't necessarily like the qualification, but we don't usually see 18-year-olds that are earning enough to actually afford a mortgage, principal, interest, taxes, and insurance. However, if you graduate from high school and you've got a great job, you could qualify. If you graduate from college, as soon as you have your degree, if you've got a job and I can have a 2-week pay stub, I can make a bridge with your college education to your job, so you don't need the 2-year job history.
Great. Yeah, that's great to know, Jan. I mean, I have yet to see, an 18, 19-year-old, like you said, and I think it might be just like, the universe in general. I think, like back in the day, maybe it was much easier for people to just get full-time jobs, without having to go to college and whatnot. But I think now the standard is so different that, young adults that actually have a full-time paying job with benefits and whatnot. Yeah, I think it's in their 20s as opposed to like 17, 18, 19. So yeah, great question though, because I think maybe that's what they're asking. And now if the person that was messaging, if that doesn't answer your question, you're more asking it like, who can, be part of your estate was maybe a question, who can actually take over the property that I want to pass on? Yeah, they just have to be a legal adult. So there's not like a rule against having a child, as long as they're at least 18, but they can actually be, in charge of the estate, in charge of the property, and take over whatever it is that you're going to take over. And we didn't dive into this too much, but by the way, the estate planning I always talk about in the event of your death, but one of the things too is, and not to go into the weeds, but when you become incapacitated, if you become incapacitated in your lifetime, that means you can no longer make decisions for yourself. God forbid you have an accident that makes you incapacitated. These are things too where a living trust comes into play, specifically if you need someone to take over your affairs. And so that is called a living trust, and that can be used also for the property. And as Jan said, you can also put this in the property. The trust, it can be the owner, so to speak, of the property, which again helps in the event of death or incapacitation. So just want to put that out there, because sometimes we talk a lot about unexpected absences, but I also want to talk about unexpected life events. God forbid something happens to you where you can't make decisions in your behalf, or you have some sort of psychological brain aneurysm or something happens. This is very relevant to what we're talking about. So the transferring of property is not just in the event of your death. You can also have someone handle the property while you're still living, but perhaps you can no longer make decisions on your behalf. So don't want to confuse anybody on that. Jan, did you want to add anything else? I think we kind of covered it, but.
No, I think you covered that, and I think people understand that, and there's documents that they can have you draw up so that they're protected. I actually, I'm doing a loan for somebody right now. They have 4 children, and one of the comments that they made was, well, I have this one, I have this one, I have this one, and this one, but you know what? This one will never take care of me. So
Oh yeah. I get that a lot. And the funny part about that, Jan, is that, I don't know who the children are half the time, because I represent the person, right? So when people have very specific ways of, this child can do this, but this child can't do that. And so only you know this, which is why you have to come talk to an attorney. And again, someone who's a live person, right? Not the internet, because again, we don't know what we don't know as attorneys, right? So I always rely on the client to really convey to me what it is that they want. Like you said, Jan, maybe there's a child, or like, there's no way this child can take care of me. They can barely take care of themselves, or something goofy like that. That's why these legal documents, which we'll talk about in a second, are imperative, because again, leaving something in writing is the best gift you can give your family, especially in the event of a death or incapacitation. So thank you for mentioning that. We have another question that just popped in, an interesting one. It says, if I don't live in my home anymore, but I own it and my children live there, can I transfer the mortgage? And I think they meant transfer the mortgage to them.
To the children, yeah. So no, you can refinance, and you can't, there's a number of ways that you can transfer the property and you can transfer the mortgage. And in this particular case, we're getting into some things that are title issues. So you were talking about the deed. The deed is a title issue, and if you haven't been on title for 6 months, it's going to be hard to do the refinance. However, if someone is now living out of state and they want to transfer, you can't really transfer the mortgage. Probably what I would recommend is that the parent stays on the mortgage, and then they have their children as owner occupants on the mortgage. If they're all willing to pay, and that's the way that they're going to do that. You can do that in the state of Illinois. There's a lot of states. I can't name them all right now, but there are a lot of states that allow you to do that. But you have to be cognizant of the fact that the title is what shows ownership to the property, and there's a history that gets drawn every time you do a financial transaction on it. So 6 months is usually the rule of thumb. But if someone is moving out, I would suggest that the primary borrower, the primary owner, stays on the title, and then they refinance and put their children on it if they're going to be living there. Now, and then they'd have a natural flow of the inheritance if something were to happen to the primary owner.
So is it a hard process? Let me ask that, 'cause I think what they were asking is when you transfer it and whatnot, is it a hard process to try to get, like you said, you can add them as, what was the word that you used? The occupants, they could be
Yeah,
occupants.
they would be, if they're living in your property and they're either buying they can also buy the property from you. So
That's what I was
that would be
gonna
like
say.
a real
Yep,
estate transaction that you would
yep.
handle. So you would actually, there wouldn't be realtors involved. So you would, as their attorney, would write up the contract, and
Mhm.
they actually could give them a gift of equity in that property, so it wouldn't cost them anything. And that would be one way to remove yourself and make a smooth transition and remove yourself from the deed. And then your children or grandchildren or whoever you're selling it to become the owners. We do a lot of that in our office.
Yeah, and actually, I do a lot of those as a real estate attorney because I'm glad you're mentioning that, Jan, because I think that's one of the things that not everyone fully understands, that this is an option. So, for the viewers that are listening, there is an option that you can buy the home from your parents formally. Now, a lot of people will call and say, "Well, do I have to go through a title company? Do I have to go through an attorney? Well, the short answer is yes. I mean, we're going to absolutely do the best to protect you and make sure that you're protected in the real estate world, but you can't just do it under the table, so to speak, because that doesn't benefit you in the long run. Kind of like Jan was saying, I think buying it from your parent, the gift of equity is super popular for people to do as long as they're informed of how it works. So sometimes people will say, well, I don't really understand the gift of equity. I have a lot of that. And so I explain it, but I think it's just hard. So Jan, what is like the simplest way to explain a gift of equity? Like, because I'm just trying to make sure that the viewers understand what that means. I know what it means, but I want to hear what you have to, how do you explain
Well,
it to your clients?
I have done hundreds of these, and I will tell you that there has not been one single case. So the equity in your property, if your house, let's use simple numbers for the math for me. So your house is worth $100,000 and
Yep.
it's paid off. All right, how much equity do you have in the property? You have $100,000 worth of equity in the property. When someone wants to sell that to a family member, it is very rare that they're going to give them 100% equity in the property. So what do? And they allow the person to get their down payment from the equity. So let's say they're going to give them 20% equity. All right, if it's worth $100,000 and they're going to give them 20% down or 20% equity, that's going to be $20,000. They might also opt to pay their closing costs, because when you purchase a home, whether you buy it, from a family member or from your neighbor, or you buy it through the MLS, through a realtor,
Mhm.
there's always closing costs involved. So,
Right.
and those are primarily the title charges. There's some bank fees, and there's your attorney fee, which is pretty nominal. But the title, again, which we didn't really intend to talk about this, but title is really one of the most important parts of purchasing a home or transferring ownership. So
Yes.
if the equity is, however, what percentage of the property is not mortgaged, that you decide that you're going to gift to the people that are purchasing your home if it's a family member. Is that clear?
Absolutely, yeah, and that's the best thing. This is why I have you on the show, Jan, because you can explain this so easily. Because again, I've had clients that are doing the gift of equity, and they do not understand the gift of equity. Now, really, the gift of equity, I mean, it could benefit everybody depending on the goals of the particular family. But I think, like you said it best, it's what you basically paid off. you know
Mm-hmm.
what you have. Yeah, you don't have a mortgage on anymore. So thank you for going into that. I know we're going to go kind of in the weeds there with that, but I just want to make sure people understand, because it is great to think about, we could talk about estate planning, how to transfer the property. But sometimes people want to do this mortgage thing that you could just transfer it like that. But it's not so easy. I mean, there's a formal way to do this. And Jan has great expertise in that. And thank you for kind of diving into that, because I think it kind of goes to the question of, how do I transfer the mortgage? It's not really like a transfer, although, there's ways to do it that way. But the other way is the gift of equity, where it completely it's not even your mortgage anymore. And actually, one of the things that I always tell people is that if you're thinking of doing the gift of equity, and as a seller, let's say you don't live there, but your children live there, because like kind of what you were saying earlier, Janice, people want to move to California and retire, and they don't want this house under the name. So there's just so many goals with that.
Well, the other thing is they might have a mortgage. So if somebody has, I mean, you can just double this for your math, whatever the home is worth. But if you have $100,000 value home, and we were talking about one that doesn't have a mortgage, but what if it has a $50,000 mortgage? Well, you're not just going to give that to your kids, and then you still owe the mortgage. So they would in essence purchase the home using a gift of equity as their down payment. It could be as little as 5% or as much as you want to give them. And then at closing, the title company would pay off the existing mortgage, however much that is. Maybe the family members who are selling the house to their family members, they need that money to retire. They're not in a position where they can just gift the whole thing.
Right. Yeah, that's a great way to put it. I mean, it really depends, right? On the person. Okay, that makes sense to me, and I hope that answered everybody's question that was asking. We just had another message come in. Their question is, how can I prevent my children from selling my home if I am incapacitated? How can I prevent my children from selling my home if I become incapacitated?
Well, first of all, I think selling your home, whether you're incapacitated or not, they're not the owners, so they can't really put your house on the market. Again,
Absolutely.
This would be another situation where if you want to protect yourself, you talk to your attorney before you're incapacitated.
Yes, absolutely. And kind of going off of that, I mean, it's funny because I feel like we answered this question ahead of time of like, how do you sell it or how do you do something if you are incapacitated? But the person is asking, if I become, how do I prevent my children? Well, there's documents that we'll talk about. One of them is the power of attorney, for example, for healthcare. In the power of attorney for healthcare, and there's also a power of attorney for property, every person should have one of these, regardless of income, regardless of what you own and don't own. The reason is because these are documents, legal documents, that we as attorneys help prepare for you in the event you become incapacitated. And what does this actually do? This document is super powerful because it actually gives power to somebody who you've chosen, whether it's one of your children, it could be your spouse, it could be your neighbor, it could be whoever you want. That is the person who's in charge of your affairs and who's in charge of your, let's say, property. Then maybe they can sell it on your behalf if you allow them to do that in the power of attorney. So there's a lot of powers that are granted. But what's nice is that the powers of attorney actually specifically pick somebody. So if you're worried about your children or a child of yours stepping in and saying, mom's incapacitated, I'm just going to sell the house from under her. It's finally, there is no right, like in a world where we all have rights, that is not one of them. And no person has a right to sell your property in the event you become incapacitated, unless you have a power of attorney and perhaps maybe that was in the works already. If you had somebody like a spouse that was your agent, they call it, for your power of attorney, now that's a whole nother ballgame, and that they could technically have the power of attorney to do that if you've given them that power through the document. So there are ways to prevent it. And it kind of goes back to, again, the basic takeaway of today. Get these things in writing. If you're worried about your property, if you're worried about who's going to be able to do what while I'm living or incapacitated or unfortunately passed away, getting it in writing is the best way. And kind of going into this, people say like, I have so many kids or I have so many heirs. And by the way, if you don't have children, this applies to you too, because people will always say, well, I don't have children, you don't have to worry about it. It's like, well, it depends. I mean, if you have a property and you don't have children, but maybe you have, mom and dad, I don't know if you get along with your mom and dad, or do you have a brother or a sister? Like, they would be next of kin, next in line. They would be your heirs if you don't have children. So depending on your family dynamic, you may consider this being relevant to you, because people will always say, well, this is just about children. It's just in the children fight, but it's like family fights, right, Jan? I mean, Jan, you probably have seen this, I'm sure, in the mortgage industry. But do you see that a lot with children trying to get involved with affairs?
I just saw something with a situation where it was not a child, it was a nephew.
Oh,
and there's a woman who is in her 70s, a little on the frail side. She didn't take very good care of herself, and she had she wasn't like dating this man, but she had a younger man move in with her, and he was taking care of her. So he was living in her house, and he had a job, but he was there kind of in the morning and in the evening, and he gave her dinner, and he helped her out a little bit, made repairs around the house. And this went on for a long time, like 5 years.
Okay.
And she had to go to the hospital, and her nephew who's an attorney, by the way.
Oh, of course he
Sorry.
is. That's
Put
okay.
her into a nursing home, and threw up some legal roadblocks so that this guy couldn't see her at all or talk to her. And he didn't have to evict him. I mean, he asked him to leave the house, like with no notice.
Right.
And really, she wanted to go back to her house, and she wanted to continue living there. So that is going to turn out to be some kind of a difficult legal situation for this woman. And I think she did not have things legally spelled out in writing,
Sure.
so that her nephew, she doesn't have any kids, so it's her her adult nephew, just stepped in, and he just decided that he was going to take over and do things his way and take all of her stuff and take her house, and there you have it.
And this is what happens. And I always tell people, as much as I want to pretend like we don't all have a family member who's a little kooky, we all do. I mean, there's always, and I tell you, because I do probate work, I do work where there's family fighting over stuff, or even in estate planning, one child wants to be the person who's in charge. And unfortunately, it's not up to the children, it's up to the person making the documents, and that's who I work for it, technically. So one of the things I always talk about is that we all have a crazy uncle or a crazy niece or a nephew in your scenario that will come out of the woodworks and actually feel as though they're entitled to something that they're not. And this is scary because, when you are frail or you're almost defenseless in a way, it's hard to really do anything when you're not in a good sound of mind, especially when it comes to these estate documents, which I want to talk about, because when it comes to a will, when it comes to a trust, when it comes to the powers of attorney, any documentation that as attorneys we're providing for you, you do have to be of sound mind. That means you can't have any current incapacitation. And usually what happens is that sometimes people will come to me and say, my mom is getting to the age, or dad's getting to the age that we're worrying about him, but they're still okay, mentally. And then there's other times where they aren't, and there's nothing we can do. As attorneys, we have an ethical obligation to do certain things a certain way. When it comes to someone being incapacitated, we can't represent someone who's incapacitated, of course. They can't make decisions on their behalf. So they don't have the power to hire us. And so, the capacity to hire us is the word. So sometimes this becomes relevant for those viewers that are watching that are kind of thinking about doing estate planning, or thinking about refinancing for that matter, or doing anything that involves paperwork on your behalf. You have to be of good sound mind. Otherwise, it's too late. So make sure you don't wait on this stuff, folks, because people do wait more than I like on stuff like that. So thank you for that person who asked the question. We have another question that came in, and Jan, you may want to remind our viewers where you are licensed when I asked you this question, because I think they're asking it for you, because there was a flag or a banner that came up that said you were licensed in Florida. Is that correct?
I am. Florida, Illinois, Wisconsin, Georgia, Washington State, and California, and Indiana.
Okay. Perfect. Okay, great. There you have it. So here's a question for you, maybe to help this viewer answer this question. It says, if I have property in another state like Florida, what should I do to protect my assets after I'm gone?
I think that this is another question that it doesn't matter really where the property is. So there are different rules and regulations for every single state. Some states, I know that we have a transfer, a TOD, a transfer upon death deed that you could draw up for people. Florida is not one of the states that accepts it. I know that there's 25 states that do, and you'd be an excellent guide for somebody in this particular situation.
Yes.
So that would be really good, except in the state of Florida. However, I think that you can protect your property in other states through your living will. In an effort to direct people to how they can best be protected. I think you can probably you can answer that better than I can. You can direct it over one umbrella, and then that covers everything, no matter where you have it. It's pretty complex, and don't try this at home.
Yeah, I appreciate that. And actually, I'll ask you in a second, Jan, but when we were talking about Florida, I think this person might have been, and I will answer this question, but I think they might be asking about the mortgage, like, can they do anything with their mortgage? So maybe we'll talk about that in a second. But yeah, Jan, you're absolutely right. In other states, again, they're called TODIs, transfer upon death instruments. Those are typically accepted in most states. Some states no. And in some states like Illinois, we have them. Not all attorneys do them as of right now. Doesn't mean that you can't find an attorney to do it. But the reason is because they're so, I would say there's not a lot of precedent on these things. There's not a ton of cases to really direct the courts on the TODIs, the transfer upon death. There's other states like Wisconsin where it's totally acceptable, and there's a lot of precedent and case law to back that up, and it's no problem. So again, going to the right professionals to kind of help you with that is the best way. A living trust is a great way to navigate properties that are outside of the state of Illinois. Again, we help you as much as we can prepare for those types of things. There's a lot of nuances and stuff that when you're talking about out of state properties that you'd want to put into the trust, but a trust is the best way to protect the asset, especially in the event of your death. In Illinois specifically, the trust has a lot more, we're going to call it weight when it comes to death, because when someone has passed away in Illinois, and they have a trust, they can automatically avoid probate. It's almost like they don't have to go to court. They don't have to hire an attorney like myself to go and represent their estate to try to get someone to oversee the estate. And so I always talk about the trust being like a basket or a,
good analogy.
Kind of a bucket of putting everything in your bucket. And then if something is left out of the bucket, unfortunately, you do have to go to the court, and the court supervises the administration of the estate and appoints somebody to do that. And that could be, in Illinois, at least Chicago, it's about 18 months.
Very costly too.
14 months if you're lucky. Yeah. I mean, it's very costly. You're talking an average of like at least $20,000. And that's a big, estimate, because depending how many errors are coming out and disputing things, and it could get pretty messy. But the idea being that, again, there is always a way to to prepare for your assets being protected, and estate plan is the best way to do that. Jan, is there anything that people can do for their mortgages? Like, for example, I know, and maybe because this person might have been talking about that, if they have property in other states, how do they go about this when they're trying to rearrange, like let's say somebody passes away and they have a house in Florida. Obviously, I talked about the estate plan, but what happens to the mortgage? What is your best way to describe that?
That's going to depend on whether or not someone, let's say I have a house and I die, and my daughters want to keep that house. They don't want it to go into foreclosure, and it's got a mortgage on it. So it would behoove them to continue to make the payments. As long as you continue to make the payments, I think the bank will leave you alone. But once you stop making the payments, and after 3 payments, the bank, and it states this in every mortgage document, they have the authority to go in and start foreclosure proceedings, which again is very expensive. So if your parents or grandparents have property in another state, and you know that you are going to be interested in having that property, or that that they want you to have that property, I would make sure that arrangements were made for the mortgage to continue to be paid. Of course, if there's no mortgage on the property, you still have the issue of ownership. So the mortgage is the financial instrument that you have to pay in order to clear the title. But there's still the deed, which can either be clear if there's no mortgage or not clear if there is a mortgage on the property. So there's got to be somebody who's controlling or willing to take responsibility to make sure that everything is paid and handled. And if you can't do it, then you have to have your attorney do it.
Yeah, absolutely. And one of the things I want to talk about too, when someone does pass away, I mean, a lot of times it'll be, unfortunately, a spouse will pass away and both people were on the property. Again, surviving spouse usually is okay, especially if they continue paying the mortgage, as Jan said. I say usually, so like disclaimer, not every bank's going to be as forgiving, but disclaimer, because, I can't speak for every bank, but typically, right, speaking, there's a way to continue paying if you wanted to do that. Now, also as attorneys, I help a lot of people when their spouse has passed away and then they want to sell the property, to clear up the title, to fix the deed of the property so that they have the ability to do that. And I don't know if you've seen that a lot, Jan, but we do a lot of like joint tenancy affidavits that are needed for us to take someone off the property because somebody has passed away, to clear up the title so they can sell. So there's a lot of things that happen when someone has passed. So I just want to point that out because it's not always so easy, you know, like you said, Janet, just everything depends on the persons. It depends on their personal issues, right, that they're facing, and who's gonna do what. And I'm glad that you mentioned the part about if you want to continue paying the mortgage, you can, because that is the biggest question we get at our office. You know, so-and-so has passed away, should I keep paying the mortgage? You know, and it's always a hard question because it's like, well, what is your plan, you know, first? Because some people say, well, we're going to sell it, or we're not going to sell it. We're going to keep it in the family. So those are two different things. Do you get those questions, Jan? I know I do.
I do all the time. But if the problem is, if they don't pay the mortgage, they take away any power that the surviving people might have,
Right.
because then the bank becomes in charge.
Right.
So that's a very slippery slope. But of course, then who is going to pay it? I mean, obviously, I don't know if obviously, but it should be paid out of the estate. You know, I mean, if the person passes away and they've got assets and they've got money in the bank, then obviously you'd pay it through their the money that they have, because it's their house until things get sorted out. Probably the best thing to do is to be able to have some kind of term life insurance on your mortgage, so
sure.
that's paid. And that eliminates all of, you know, not all of this, but it eliminates a lot of it, eliminates some of the financial crisis that happens when somebody dies.
Absolutely. And I love that you brought that up, because we actually had an episode about life insurance. And yes, I agree with that 100%, especially because we can't assume that when someone is a surviving spouse, or perhaps there's surviving children of the person that has passed, that there's enough money there. You know, I think that's one of the biggest things that I come across, is that just when you think the family has enough, you know, they end up not having it because they have, you know, all these other things to pay for, and they don't know what to do with the house. And so there's a lot of options. So please do yourself a favor, do your family a favor. Again, contact me, contact, you know, Jan, if you need help with any sort of mortgage questions regarding this, because you do have to know the next steps, you know, and obviously, you know, there's so many schools of thought when it comes to this by people. And I don't mean that for professionals, but, you know, as attorneys, we're never going to advise you to stop paying your mortgage if the bank comes knocking your door and forecloses. We're never going to say that. But you do want to be informed about your options, because some people think that they have to pay the house off immediately, and not necessarily, not necessarily. And sometimes people want to sell it, and then there's a way to do that too. And so there's so many options out there, guys, when it comes to real estate and what happens in the event of a death outside of your estate planning, which you are already know about. but in general, that's something else that I wanted to touch on. Jan, did you have anything else you wanted to share? I don't have any more questions for you today.
I would say one last thing in closing is that there are a lot of different kinds of mortgage, and you're talking a lot about, people passing on. So there's also the possibility that if your parents or your grandparents took out a reverse mortgage, and we don't really need to get into the details of what that is, but let's say somebody's 80 years old. The house is worth $100,000. 2 months ago, that house was paid off. They didn't have a mortgage, but they want to get some cash out for themselves so that they can remain in their home and not go into a nursing home. So they may have taken out a reverse mortgage, which gives them the cash, and then they're just responsible for the taxes and insurance. Well, then they go away on vacation and they have some kind of an accident and they get killed out of state, and this reverse mortgage is still on their property. Maybe the husband took it out and he's 80, but maybe he was a hot 80-year-old and he's got a 50-year-old wife. She's going to have to move within 12 months. So there's a lot of complications involved in home ownership that shouldn't scare anyone away from buying a house, but it should encourage people to get the right professional advice along the way. And that's why I would call you, Stephanie.
Yes, thank you, Jan. And I appreciate you mentioning reverse mortgages. We actually covered this topic last week, because reverse mortgages, it's a tricky thing. I mean, I think people do not fully understand all the time what a reverse mortgage is. Not
my favorite.
Not my favorite either. And I was going to say, I don't say that they're the greatest mortgage out there. Sometimes people have to do that because it makes sense to them and financially they're where they're at because, they sort of need it. But it is not something that we are going to have you sign up right away. So if you are thinking about doing that, instead of signing the papers without asking anyone, please contact your attorney or me or Jan to kind of help you with this, because reverse mortgages is a great topic. That could be a whole other topic in itself, but they're very tricky. There's a lot of fine print, and that is because they're very popular. And so they usually target certain markets, unfortunately, our elderly communities. So just something to think about, you guys, as we are wrapping up here. But Jan, if anybody wants to get in contact with you, where can they contact you?
They can contact me at my office in Libertyville, 847-362-1335. I see that my email's up there. They can contact me by email. My cell phone is 847-293-2111. A good way to reach me is by text. I can hear my phone going off over across the office. So I've probably got some text waiting for me. Because I used to be a teacher, I'm happy to work with first-time home buyers and walk people through the process. I can do that either in a conference like this, like on a Zoom call, or we still do have a lot of people coming into the office and we sit down and we go over things, because some people are more visual and they really like to see the numbers in black and white on paper, and they feel a lot more comfortable before they go forward with their transaction.
Yeah, absolutely. And thank you again, Jan, for all your information, your expertise today. This has been wonderful and a pleasure to have you on this show, because to us, it just sort of helps our viewers understand and really educate themselves on what it is that they're seeing online and what they hear about over the radio about mortgages and property. And, one of the things I hope that the viewers will learn today is how to transfer the property in the event of your death or incapacitation outside of getting mortgage advice. There's a mortgage and real estate and estate planning. They're all married. They're all complementary to each other. They have everything to do with one another. So
it's like a puzzle. Everything fits together.
It really is. Yeah. And there's not one piece that can't go with the other, because they're all super connected. So thank you for your expertise. And I also want to thank our viewers, our loyal viewers who are watching us all the time. And they love asking questions. It keeps us on our toes, so we appreciate that. And as always, Pink Mike Leo Confessions is here every Tuesday at 2:30 p.m. And I cherish the opportunity to earn your trust and helping your family with a plan for your future in your estate planning or perhaps in your real estate needs, always offering that as well. So like anything else, I always talk about this. It's worth it to do financial planning, estate planning, and just planning for your future. So we always encourage you to reach out to discuss with us. If you need help, you can text or call the line 773-373-9592, as you see at the bottom of the screen. And I'd love to speak with you. Consultations are free, and they are either in person, if you'd like. We have plexiglass, we have hand sanitizer, or we can do it from the safety of your own home, which is what people are liking these days, because they can do it in their pajamas. So they have no problem with that. So I invite you guys here back in Tuesday of the following week at 2:30, Pink Mike Leo Confessions, where we cover topics that are important to you and your family, so you learn something that you didn't know when you started this video. And so I'll see you guys here at the same place, same time. And please keep in mind too, we are a fully bilingual firm. We speak Spanish. In case anyone of our viewers needs a Spanish speaking attorney or legal services, please don't hesitate to reach out. We are very, very comfortable in speaking with that community as well in the event they need our assistance. So we invite friends and my family and friends and actually our viewers to share our video all the time to people that may need it. I know a lot of people like watching these because they get educated. And again, our goal is to make sure that you learn something that would help you and your family. So I hope everyone has a great week this week. Stay warm. I know there's supposed to be a blizzard coming if it's not over yet. I think we were in it yesterday. But if you need anything, our email and information is at the bottoms of the screens. And Jan, again, thank you so much for your help today, and appreciate you as always.
Thanks a lot, Stephanie. I appreciate it. See you at the closing table.
Yeah, absolutely. I'll see you there. Thank you, everyone. Stay well and take care.